All right, our last case this morning is 2020-228, the Toledo Bar Association versus Thomas Allen Yoder. For the respondent, Mr. Yoder. Counsel, you'll have to unmute your microphone.
Can you hear me now?
Now we can.
Okay, you can hear me?
Yes.
Okay. My name is Thomas Allen Yoder. I am 68 years old. I have been a very respected member of the Toledo area legal community for the last 42 years. I have had a very varied practice, and in my humble opinion, this entire proceeding against me has been an absolute joke. If I could, I would direct the court's attention, if we could, to the bottom of the findings of fact on page 11, where whoever authored the opinion stated, indeed, while this matter was winding through pretrial proceedings and while respondent was represented by counsel, respondent himself filed a 63-page second amended answer with 34 exhibits after, and whoever the author was, underlying the word after, his attorney had already filed an answer to the same amended complaint, all to reassert arguments in the underlying case as ostensible and to reassert descripers for opposing parties, lawyers, and judicial officers. In this case, respondent did not approve of the answer filed by his counsel solely because he insisted on the over-the-top factual arguments, procedurally incorrect inclusion of materials well beyond the mandate of Civil Rule 10. That is absolutely insane. It is crazy. I filed my amended answer on July 12th. Martin Moeller filed his answer on October 17th. Whoever authored this, I don't know what world they live in, but July 12th comes before October 17th. I said this whole thing has been absolutely unbelievable, and that's just an example of it. And like I said in my objections, if anyone wants to check the veracity of any of the findings in this, they should look to that phrase. Transcript number 355 sets forth what really happened. Mr. Dawson, I think we may be able to short circuit this. Realtor would be amenable to having the respondent's last self-filed answer to the prior complaint for the second amended complaint with his general denials be his testimony. Me, that's fine with me. That's fine, I will stand upon it. I think it was filed on July 17th. I filed a response and answer of 64 pages, and I think I had 34 exhibits to back up all of my assertions. I did not file that to hassle anyone. It was filed. It is 64 pages. It is an affidavit. It has 34 exhibits in which I deny each and every allegation in those paragraphs. It's very comprehensive. It is not, I deny, I admit, and so forth. I said in there that it was very professional, bespeaking my experience that I've had. The case also took a very strange turn. October 22nd, 1919, Joseph Dawson filed a motion before the board, which is quite embarrassing. Mr. Dawson filed a motion and he wanted to have the board deny me calling any witnesses and to deny me calling any exhibits. I cannot imagine when any of you were on the common pleas bench, if someone came in and said, I don't think the defendant should be allowed to call any witnesses or any exhibits, you would take it seriously. I think that this is absolutely a joke. The reason that Mr. Dawson did not want me to call any witnesses is because all four witnesses that I called at the, before the panel backed up exactly what I said. September 30th, 2015, I walked in for a very short hearing whereby a drug addicted, mentally unstable mother was going to sign the last of her 3 children over to her parents. I walked in, we had her consent. Half hour later, we walk out. The magistrate made a ruling that the children were in immediate, imminent danger and that they needed to be removed that very day. It is still one of the most stunning decisions I have ever seen in my practice.
Counsel, you
was a-
you seem to be relitigating what happened in the trial court level. That's not why we're here. We're here based on the complaints against
We're
you.
breaking up badly.
I'm breaking up? Did you say you can't hear me?
Yes, ma'am.
Can you hear me now?
No, I can hear you now. Yes.
Okay. You seem to be relitigating or wanting to explain why you should have
Frozen.
prevailed below. That's not why we're here. Can you redirect your focus to why we're here, sir?
We are here because the findings in the report are not accurate. They totally ignored my witnesses. They claimed that I badmouthed the magistrate. My witness testified that the reason that the children were removed was because the magistrate did not like my client's attitude towards him. That is why we're here.
Counsel, do you deny what you're alleged to have said and written and, in any of these 3 cases?
No, I said those. They are all very truthful.
Okay.
Everything I said about the magistrate was absolutely 100%. When we got down to the stage after that, like I said, a poor little girl was taken away by the magistrate. She should not have been. Everything I said about that magistrate is true. My witness backed it up completely. She claims that he acted improperly. He should have gotten a hold of an attorney. He was mandated to get a hold of an attorney and have the attorney check over what happened. He did not follow the rules. As a result, the little girl ended up going through a very traumatic experience, all because the magistrate thought that he was disrespected. There's other things in the findings of fact that are completely inaccurate. Page 10, respondent leapt to the conclusion that the respondent himself was being blamed by Mrs. Dow for the rape, and he stood accused by her of having covered it up. Whoever wrote the opinion did not look at the January 11th, 2017 Get Professional Help email, where in fact, I was accused by Cody Dow of covering up a rape of a 14-year-old girl. She said that her entire reason for being involved in this case was to prevent the little four-year-old girl from being like her mother. And she also threatened to blackmail us. My contention is this whole thing came about because the woman has some very, very serious problems. Problems that I should have, and I was obligated to report to the nursing board. The woman thought that my son was out following her. If she thinks that my son is a private detective, like she put in the letter to the Bar Association on December 5th, the woman's got some problems. And I have an absolute obligation to report her to the nursing board. She claims people are following her, people are videotaping her. They were not. Like I said, I have an obligation to do that. Going on to the case with Fan Zhang, I did everything right. Mr. Zhang lied to his clients. He told them that the transfer of title to property negated their recorded land contract. I have kept that up for the last 9 years. I solved the problem. I thought that's what attorneys were supposed to do. I have exhibit WW, which showed that I did everything possible. I have acted as the escrow agent for the last 9 years. I have paid everything out. Van Zang lied to his clients and told them that I was stealing money because I wasn't paying the original mortgage holder. I also contend that a lot of this was done through ineptitude. I have sent copies of all of the exhibits to everyone concerned to let them know that I was in fact not stealing the money and I was doing the job that I should have done. One of my contentions is that the Toledo Bar Association has done an in-depth job on this. The exhibit they had, number 34, when it went before the panel, the only thing it went back to was 2012. The Bar Council had at least 5 copies of that recapitulation and never even looked at them. Same thing with the title holding agreement. I contend there was a problem. I turned around and I solved it. My client, Jeff Maris, was in ill health. We were going down to the Big Ten Championship, my son and I. I explained to Mr. Maris that I would hold property in trust for him. He had one son who lived in Washington, D.C. He wanted any money left over. I submitted the title holding agreement. It's in the file that I filed on July 17th. It clearly sets forth 1.7 and 1.8. I submitted it to Bar Council. Bar Council filed several complaints saying that it did not include it. I showed it to him. He then changed the directions and went back and filed against me for having a pecuniary interest in the title holding agreement, which would occur in the year 2026, 15 years after I took this. I contend I have done nothing wrong in this. There were problems that I solved, as any good attorney would do. I saw them. I took care of it.
Counsel, let me direct your attention to the findings of the panel. Professional Conduct Rule 3.5A6, undignified and discourteous conduct that is degrading to a tribunal. And that is in relationship to what you've said and written about the magistrate. Are you saying that what you said, the statements you made about the magistrate were not undignified or discourteous conduct that degraded the tribunal?
They were true. Absolutely 100% true.
Counsel, that's not what I asked you.
Yes, they were degrading, but it was also true. Everything I said about him. Pardon me?
They were discourteous as well as undignified.
Okay, well, I respectfully disagree. I put down exactly what happened. It is not my fault that the man cannot function as a magistrate. He lied. As I put in my opposition, I put the 2 paragraphs together. My witness, Martha Rywald, backed me up 100%. When he told us that he had talked to Barb Cummins before he removed those children, that was a flat out lie. In my affidavit of prejudice and bias, I put in there that he had lied because he thought Barb Cummins agreed with him. 2 years later, Martha Rywald gets up and agrees 100% with me. Now, I can't help it that the man cannot function as a magistrate, made irrational decisions, lied to us, and so forth. Judge Zimmelman agreed after listening to the tape that there was far too much contentiousness in the courtroom, and it didn't come from me, and it didn't come from Mr. and Mrs. Brooks. It came from the magistrate lecturing us as to our conduct. I don't have to put up with it. Mr. and Mrs. Brooks do not have to put up with it. All he had to do was act like a normal magistrate. You do not pull two children away because you do not like grandma's attitude, period. Now, I didn't create the situation with him. I did not create the situation with Fan Zhang. I walked in for what should have been a 10-minute hearing, and the next thing I know, I'm being accused of rape. My son is being accused of following her, and I had an absolute obligation to report that to the nursing board. Same way with Fan Zhang. If you look at the answer that I filed, I did everything right. Fan Zhang lied to his
Mr.
client.
Yoder, you've used your time.
Okay, thank you.
Mr. Dawson, if you'll turn your microphone on, we'll hear from you.
Chief Justice O'Connor, Associate Justices, Mr. Yoder. May it please the court, on behalf of the Toledo Bar Association, let me first address a few of the things that Mr. Yoder has said. As is painfully obvious, the reason that the motions in limine were filed was to try to avoid relitigating the matters below. I thought Chair Collins did as admirable a job as he could with giving Mr. Yoder leash to try to present a case and still try to avoid those underlying litigation, which is not at issue. Respondents' essential objections here are that the findings are unsupported. And although the author of the report may have gotten those dates mixed up, what is most critical and most obvious to this court is the manner of that answer. It did not comport with rules 8 or 10. It was essentially a diatribe with affidavits and exhibits. And rather than go through trying to make some sense out of reinstituting that and raising it at the hearing, I simply agreed, again, as an acknowledgement to the shortness of time, let that amended answer stand, let his testimony at the hearing essentially equate to the denials of the amended complaint, and let's get to the merits of this and be done with it. The panel's analysis and its findings were based on respondents' writings and his testimony. The exhibits alone established the case by clear and convincing evidence. The testimony essentially made the case established the burden as beyond a reasonable doubt. The panel's determination of credibility, as this court has recognized, is entitled to deference. They saw and they heard the witnesses firsthand. There was nothing that weighed heavily against any of the findings. The panel did not lose their way. Respondents' conduct was the issue, not the merits of the underlying case. And although the exhibits alone met the burden of proof, Relator called the witnesses to establish the dissonance between Mr. Yoder's beliefs and the facts as they came out. Two of the very witnesses that he called, both the guardians, magistrate, or I should say Attorney Rewalt and Attorney Bryant, both stated that they did not feel that the magistrate had lied. They did not say that his opinion was unfounded. I mean, it is unsettling to read the transcript and then hear Mr. Yoder's objections. Even his defenses that were unrelated to the underlying cases had no support. I'm only human. I was simply reacting to the aggravation and the irritation. The magistrate's hearing that he's talking about happened in September of 2015. If the court would look at the exhibits, his objection to recuse the magistrate was filed in 2017. There is clearly a premeditation that was involved in these filings and these statements that simply vitiate his arguments that he's simply human and responding in the heat of the moment. Misconduct here was his mistreatment of third parties. The judicial officer, Magistrate Aja, Mrs. Dow, the Thomases, the Zhangs, and the subpoenaed witnesses. In each of these underlying matters, when he was challenged or aggravated or irritated, his response lacked any sense of proportionality, instead focusing on intimidating, burdening, and in short, bullying. Now, I know the court has reviewed the briefs and most importantly, the panel's report. So I won't present the principal points of the mistreatment of each of these third parties unless you'd like me to.
Counsel, would you address one of the recommendations is OLAP, an OLAP evaluation and then compliance in the event that there's found to be a need for an OLAP contract, correct?
That's correct, Your Honor.
All right, can you expound on why that's necessary here?
Well, in this case, and I concededly, it's a less common part of this matter. There's no evidence of depression. There's no evidence of substance abuse. So why do it? And it's because of respondents' dissonance, the dissonance between his beliefs and the dissonance with the facts as they were established by these witnesses who testified. Further, in addition to that, it's his deviation from the professional acumen that he's clearly shown in the past. He's been at this for 40 years. He's been involved in litigation up and down the various courts in Northwest Ohio, federal and state. How does that experience and that background rationalize the filing of the pro se answers in this case that did not comport with Rule 8 or 10? How does that background comport with the very objections that were filed with this court? It's as though Mr. Yoder sat down with a dictating machine, dictated the caption, and then sat there and did a stream of consciousness for an hour and a half and concluded it with a certificate of service. There's no compliance with this court's rules.
Counsel, let me ask you, was there testimony that up to this point, Mr. Yoder was professional and the antithesis of what he was exhibiting during this disciplinary process?
Your Honor, I think Judge, bear with me, but I think Judge Zimmelman spoke to that she had known Attorney Yoder before, and his allegations that he attributed to her, the statements that he attributed to her, were entirely unfounded. She did not go into any greater detail, and frankly, we didn't present any other witnesses that would have established the difference between what we are seeing here and in those cases versus how he presented himself previously. Mr. Yoder has been an acquaintance, and I'll not speak further. I did not testify. We believe that the panel took the evidence that was before it, and it is, again, worth reviewing the descriptions that the panel submitted of the various testimonies that were presented in paragraphs 8 through 13, I should say 14. They stand in stark contrast to what Mr. Yoder claims that they said. The aggravating factors that were reviewed under Gov Bar Rule 5, Section 13 by the panel: disingenuous claims and recitations, dishonesty, that would be B2. Essentially, it was replete in this case, the reckless disregard of truth. That was endemic to all three of these underlying events. And not coincidentally, that phrase comes from Rule 1.0 defining fraud, one of the alternative prongs for fraud. And that's Mr. Yoder fraudulently described the magistrate, he fraudulently described Mrs. Dow, and he fraudulently described his authority to file this claim in Sylvania Municipal Court after it had been pending before Judge Jennings, again substantiating the finding that his filing of that case was entirely frivolous. His refusal to acknowledge misconduct, that's certainly on display here. His claim he's just having a bad attitude and responding and reacting to all the aggravation he's had to put up with does not hold water. There's nothing, and I've said this in one of the other briefs, there's nothing in this process that gives Mr. Yoder pause. Multiple violations, 8 different rule violations. Goodness, we started out with 19 that we were alleging. The 6 were dismissed by the panel. And it again underscores some of what's going on here. Mr. Yoder spent time talking about the trust agreement when that allegation was dismissed. Vulnerability of these third parties. The magistrate never had an opportunity to defend himself. And what is more damning for Mr. Yoder in this case is that he filed the motion to recuse the magistrate in July of 2017. If you look at exhibits 14 and 15, he's still at it. In February of 2018, he is again reasserting that the magistrate lied and that his decisions were unfounded. In mitigation, he has no prior history of discipline. That's undisputed. Cooperation, I have it in question marks when you look at what he filed and the manner in which he attempted to present his case did not simplify things. It only exacerbated the time and the efforts that were required by everybody to deal with this. The panel accurately concluded the aggravating factors here overwhelmed the mitigation. This case does call for actual suspension. If you look at simply the abuse of a judicial officer alone, that warrants time off. When you add in the misconduct, the attacks on these other individuals, on Ms. Dow, including her husband, he was added into the letters to the Ohio Nursing Board too. Mr. Yoder never had an opportunity to see them acting as nurses. This was simply a gratuitous attempt to affect them being out of the litigation for the benefit of his clients. When you add all that in, the sum total of all that misconduct compels an actual suspension. Now, the relator requested 2 years and 6 months stayed. Frankly, that can be rationalized. If you give time off for the magistrate of 6 months, time off for the Dows for 6 months, time off for the Thomases for 6 months, you can see where we were coming from. But the panel analyzed this case based on prior cases, as it should have. It recommended 2 years with 1 year suspended and conditions, including the referral to OLAP. The cited case law included indefinite suspensions where the respondents had no prior discipline. Indeed, in Pullins and Donchatz, both of those attorneys had no prior history of discipline. I will simply add this as a matter of perspective. We certainly abide the recommendation. We did not object to it for this suspension, but this court should remember that both the Dows and the Thomases asked that Mr. Yoder be disbarred for his attacks against them. The panel's rationale was not to punish, but to inform him that the conduct was wrong. The deterrent effect of that is the protection of the public. Even abuse to third parties will not be tolerated. There's also a deterrent portion for him in that the stayed portion of the suspension would be a reminder that there would be consequences for future misconduct. And we've already discussed why the referral to OLAP should be made for unaddressed mental health issues. In conclusion, this case underscores that mistreatment of adversarial third parties, as well as judicial officers, clients, and staff members, should not be tolerated by our profession. Based on the panel's report, the board's recommendation is uniquely tailored to this case. They've complied with the requirements in GovBar Rule 5, Section 13, in presenting the recommended sanction of a 2-year suspension with 1-year stay and conditions, including referral to OLAP. They did so by weighing all the evidence, by considering the precedent established by the prior decisions of this court, and by considering the aggravating and mitigating factors set forth in that section as presented by this case. This evidence, I should say the evidence in this case, clearly and convincingly establishes the violations found by this panel. Likewise, the recommended sanction is warranted and fits the case. Respondent's objection should be overruled, and the recommendations of the board, incorporating that of the panel, should be adopted by this court. We thank you for your time.
Let me unmute myself. Mr. Yoder, you've used your time. You may take 1 minute.
Again, there was 2 situations that I did not create. I walked in, like I said, for a 10-minute hearing, and the next thing I know, everything went south.
Counsel, could you focus your time on the OLAP recommendation?
I have absolutely no issues whatsoever. Like I said, I have no problem. I have been a respected attorney in the Toledo area for the last 42 years, had absolutely no problems. I'm not sure, and I'm being very honest, what else I could have done in these 2 cases. I mean, I didn't create the situation with Van Zang lying to his clients. I'm the one that solved the problem. The same way with Magistrate Adja. I do not have to sit back and put up with him and his abuse and have Mr. and Mrs. Brooks put up with his abuse and the things that he did to them.
Thank you. Thank you, counsel. We'll take the matter under advisement. You'll be notified of our decision.
Thank you.
Marshall, will you adjourn court, please?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.